All right, Ryan, what is on your radar?
Emily, I am looking at Salem Sam. So Justice Samuel Alito, in his draft opinion striking down Roe and Casey, relied on some rather extraordinary figures to make his case, going back to the 17th and 18th century England to cite what he said was common law precedent against the legality of abortion. Now, some scholars have rejected his history as cherry-picked and not an accurate understanding of abortion and the law back then. But for today, let's just assume that he's correct and that common law in the 1600s did, in fact, ban abortion. So the two men Alito relies on most heavily are Sir Edward Coke and Sir Matthew Hale. Now, people have already picked up on the fact that Coke and Hale are responsible for crafting many of the laws around witch trials, defining how they should be performed, who counts as a witch, and how they should be executed. Now, you might think that alone would be enough to discount their takes on abortion, which at the time they were alive was quite dangerous and either involved some type of medicinal attempt or an unsterilized procedure that could easily lead the woman to bleed out or die later of an infection. Childbirth, too, was extremely dangerous, with cases of, quote, baby fever routine. But even setting all that aside, it's telling that Alito relies on Sirs Hale and Coke for their broader views on women's rights, or more accurately, that women do not have rights at all. So both of them believed and used their position at the height of the legal world to enforce that women were effectively an appendage of men and that a woman's father or later her husband had essentially full legal authority over them. So Alito notes that the Constitution includes no reference to abortion, but it also includes no reference to, say, divorce. And if we went by common law at the time of the founding, or the time Sirs Hale and Coke were executing witches, divorce would be basically impossible for women today. Now, women also had no right, according to William Hale, to refuse their husband's sex, and therefore a man could never be guilty of raping his wife. That notion wasn't completely eradicated in the U.S. until 1993. Coke and Hale also both believed it was the man's legal right, and in fact his duty, to beat his wife to keep her in line. Hale made sure to say that a man shouldn't beat a woman in anger, but only for a purpose and in a composed set of mind. There was, of course, no separation of church and state at this point, and religious duty and legal duty were linked. Now, I bring this up not as some sort of historical gotcha that undercuts Alito's argument. Alito can just go and find some other way to justify his decision. That's what he would do. What strikes me about it is Alito's choice to do this. He didn't have to spend several pages talking about these guys in his opinion. In fact, if he was trying to be clear that all of this is really about babies and the unborn and the Constitution and totally not about controlling women and empowering an old school version of the patriarchy, the very last thing he would want to do is root his opinion in the words of men like Sirs Coke and Hale. This was a deliberate choice, and it feels like spiking the football, a way for the 5 Republican justices to say, yes, this is about using the state to restore the power of the patriarchy. This actually is about women and their place in society. And so rather than do my normal thing and run through another few centuries of history here, I'll just wrap it up now, partly because I still have COVID and was too tired to prepare all that history, but also because, Emily, you know this as well as anybody, although you come at it from a different perspective than I do. So what am I getting wrong here? How is this not Alito kind of screaming from the mountaintop that the vision of Sir Matthew Hale is now restored in the law?
There's actually a really fascinating answer to this question, and it's because Roe actually cites Hale as well. And what Alito is doing, and this is why Roe has always been, I think, shaky. And even Ruth Bader Ginsburg was critical of Roe, I think for the reason, particularly because of its interpretation of the 14th Amendment, which, as Alito says in this opinion, it has to be sort of deeply rooted in the nation's history and tradition to qualify under the 14th Amendment. And that's the argument that Roe makes. And so in the section of Alito's opinion, which is like 98 pages long, where he's going through common law history, he's not even talking about America at that point. He's actually just litigating how it was discussed in the common law, kind of pushing back a little bit on how Roe interpreted common law and saying, actually, there were different sort of standards, quickening standards, all of that going on, to say basically that he's taking this tour sort of the Western legal tradition to get up to where we are now. And he's saying, contra Roe, this standard is this right to privacy is not deeply rooted in the nation's history and in our concept of, quote, ordered liberty, which is actually the standard that Roe set. And that's why I think, honestly, Roe, it's, when we talk about why this is like shocking to some people, it shouldn't be surprising to anybody, because as much as people talk about settled law, I don't know, Ryan, how you sort of feel about Roe itself and the legal question, but I understand why so many pro-choice people and feminists have been scared for so long, because Roe is just not is just not on the most solid legal ground by any means. And I do think Alito was sort of champing at the bit to go in on that 14th Amendment question.
And do you think that, see, the reason I've been skeptical of that idea, and I agree with you in the sense that I've heard from lots of different legal scholars that everybody seems to agree that Roe was poorly written, that it wasn't well constructed, that perhaps equal protection would have been a much smarter way, since not everybody can get pregnant, it's unequal to ban a procedure that only applies to people who can get pregnant. It's whatever equal protection kind of analysis you want to apply to it. So I would stipulate that. I think didn't even Ruth Bader Ginsburg say there wasn't terribly well written opinion. But that feels to me like a sideshow, and I'm curious for your take on it, because to me this is about power, and this is about Alito being on firm legal ground only because he has 5 votes, and that's all this is. And they control state legislatures, they control the Supreme Court. They had more than 50 senators in 2015, and so they could block Merrick Garland from being a Supreme Court justice. None of that has anything to do with how well Roe is constructed or not. So if Roe was written by the most brilliant legal scholar of the 1970s, and everybody from right to left said, we don't, even if we don't agree with this decision, it's crisply argued and well reasoned and rooted in history, and so therefore we're going to leave this issue alone. We're not going to organize an entire kind of movement to overturn this precedent. I don't see that happening. I feel like the right still would have pushed ahead on this. No, or do you think it? I can't see it being any different. I just feel like Alito would have found different things to argue.
Alito may have. I don't think that's unfair at all. But whether he would have 5 votes is a totally different question in my mind, because I think there is a very reasonable, and again, this is something that Ruth Bader Ginsburg expressed, a very reasonable concern with the federal override of people's will in different state legislatures. And so I think that's genuinely something that is objectionable. And Literature Lady, the account, so this is interesting. She kind of gave the game away in her tweet where she said Hale's fingerprints are all over our legal system. So yes, that is a sad reality, and that's not to say brilliant people haven't had horrible ideas, but it is sad reality that some of our law is rooted in these really, really bad ideas. But that's why I think Alito, when he was doing, actually, I have his quote here. He says in the second part of his decision, "We examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we have described as ordered liberty." And so in order to do that, he had to do this mirror image of Roe, and it's actually sort of weird how it's a mirror image of it, and go through the common law question. But it's interesting, Roe has been protected, Casey decision is a good example, by Republican-appointed justices for years. And that's why there's deep, deep skepticism on the right of, I think a lot of people on the right were sort of very, very, very cautiously optimistic about the Dobbs case, still questioning whether Barrett and Kavanaugh will sign on to, they're signing on to the draft. The draft is written as though they've signed on to it, but questioning whether Barrett, Kavanaugh, and of course, Chief Justice John Roberts are in favor of this, just because they have seen, I think, what could be described as timidity on the question of abortion from Republican-appointed justices for a really long time. So I think your question is a good one. I think Alito is an outlier in terms of appointed justices on the right. So yeah, I think you're right. He would have probably eviscerated whatever prior precedent there was.
And it's kind of just it's kind of mind-blowing to read him say something like, for the first 150 years of this country's founding, abortion was illegal. Well, for most of that time, women couldn't vote. It's like these are like for 75 years, slavery was part of it. It's like, okay, these are These are interesting historical points that you're making. But where does it go from there? And I've been a little bit actually disturbed to watch how quickly kind of the conversation has pivoted from if they can ban abortion, next they're going to ban marriage equality. Obergefell is next. Contraception is coming. And all of the other protections that are rooted around the idea that people have these privacy rights, that they have these basic rights that aren't necessarily explicitly written in this 18th century document, because it suggests that this isn't enough to talk about. Like, in order to convince somebody that abortion rights are important, you also have to convince them that losing abortion rights might also mean that you're going to lose marriage equality. And that feels like the same kind of defensive crouch that Democrats and progressives have been in around abortion rights for so long, rather than just saying, no, forget where this is going. Yes, it's going very bad places, but where it is right now should be enough. Like Louisiana now talking about, like we said, like criminalizing women who might even just take birth control if these laws make it through. Why do you think it is that progressives are moving so quickly to what this could mean for other types of rights, rather than focusing on this very fundamental right that is being stripped away right now?
Yeah, because I don't think there's any risk to Obergefell, and partially because I just don't think there's, even if that happened, I don't think there's any constituency in any state to relitigate that question at all. I don't think anybody should be afraid about that. Ben Shapiro, a lot of people freaked out because he said Obergefell is a bad decision, and he was talking about it in a legal sense, and it is because that 14th Amendment privacy right that went through Roe, and there's many other landmark cases that were hinged on it. That's why Alito isn't endorsing the idea that we can say there's no abortion right because of Hale and because of Koch. He's saying this was your shady standard, not you, Ryan, but this was the Roe cases. This was the Roe cases standard, and it is bad. So he's litigating exactly why it's bad. So I do think that has just been a big mistake from the sort of progressive legal movement, or I should say the liberal legal movement, and so many decisions did stack on top of that. That said, I don't think that's going anywhere, because there's just, a lot of people said that about Roe forever, but these decisions also referenced other rights as well. So it's not entirely a house of cards.
We'll have more on this in a moment for sure. Stick around, Emily. Looking forward to what's on your radar.